All right. Good afternoon, everyone, and welcome to part 2 of Wednesday at the Judiciary Committee. I'd like to call to order our public hearing for March 3rd, 2021. If there are no remarks, we will jump right in. First up, we will have Mark Palka, if he's here.
We're getting him in.
Okay.
Hi, good morning, Mr. Chairman. I'm here.
Good morning, Mr. Palka. All right, we're going to get started. First up will be Mark Palka, Undersecretary of Criminal Justice for the Office of Policy and Management. Mr. Palka, you have 3 minutes.
Thank you, sir. I've been trying really hard to summarize my notes well. I'll try to keep it within the 3. I know you'll let me know if I'm running long, and I'll wrap up. Chair Stastrom, Chair Winfield, Ranking Member Kissel, Ranking Member Fishbein, and distinguished members of the committee. I'm Mark Palka, Undersecretary of Criminal Justice Policy and Planning, here to testify in support of Senate Bill 889, an act concerning the Criminal Justice Policy and Planning Division and the publication of reports and presentations by OPM. Our division was established by Public Act 05249 to provide a more effective and cohesive criminal justice system. We conduct in-depth analyses of criminal justice system data, determining long-range needs of the system and identifying critical problems. Our division works closely with executive branch agencies, judicial branch, and stakeholders, all of whom provide data and information to do our work. Our division manages a number of statutory requirements that guide a large part of our work. We produce monthly, quarterly, annual, and ad hoc reports. The 4 most major reports that we issue per year are the monthly indicators report, comes out every month, a digest of trends in the justice system, an annual recidivism study, an annual prison population forecast, and an annual report on prosecutor decision-making data. And some of our reports have looked at homelessness and overdose death among people who've been incarcerated. This bill would be the first major update of our statutory requirements since our inception in 2006, and it aims to require a new annual report on criminal justice cross-system trends to take our monthly indicators report, make it annual or even decades long, collapse multiple reports into one, place a number of requirements under the Criminal Justice Policy Advisory Commission, which we staff and I chair, and update requirements to enable our division to broaden our scope to include more front-end analysis, reported crime, arrest, victimization, interventions for people with behavioral health needs, diversionary strategies to help people avoid a criminal record. When our division was created, many of our requirements focused on corrections, the back end of the system, jail, prison, parole. Since then, we've developed skills in this area with our reports and our work, but there's a growing interest in the front end of the system, and we'd like to focus or broaden our scope to include more of those areas in our system. When we demonstrated our commitment to that with the Public Act 1959 on prosecutor data, and we're grateful for the legislature's unanimous vote in favor of that, and it led to the first intensive analysis of prosecutor operations data and workflow. And in closing, Mr. Chair, we think that updating these requirements is crucial to our division's goal of contributing data analysis to state-level strategies to address these front-end system challenges. And I'm happy to go through specific items in the bill if you would like, but I hope that overview is helpful for starters.
Thank you. Let's start with questions from Senator Winfield.
Thank you, Mr. Chair, and good morning, Mr. Palka. Just for clarification, so in the bill on lines 125 through 130, you strike section D and E, subsections D and E there. What is the impact of that?
Sorry, for some reason I had the bill fell off my screen. Master, what section of the bill, sir, that is in? And I'm going to pull that up.
It's lines 125 through 130. It's section 3, subsection D.
Okay,
and E.
Sorry about that. I do have it up now. I don't know what happened. The major, thank you, Mr. Chairman. That section relates to the monthly indicators report that we do. And attached to that report was that we study and evaluate major programs. That term wasn't defined in statute. So I don't know if we've complied with that statute over the years. There is results first that is OPM works on separately, looking at a broader range of programs. We feel that it would be challenging for us to identify across the justice system the major programs and to do evaluations of them. We would like to, though, per my desire to shift more to the front end of the system, to look at pretrial and incorporate pretrial diversion into our monthly indicators report. So that's an example of how I'm hoping to reconcile requirements that we have had challenges fulfilling, but work within our current reports to still produce value in this area.
And so I just want to be clear about what you're saying. So we would have challenges analyzing these major programs. I think the point of that section was to make sure that we actually have programs that don't sound effective, don't look effective, but are effective. So I recognize we have results first, but how do we, regardless of what the language here said, how do we make sure that the spirit of that section is, how do we guarantee to myself and others that the spirit of that section is still in effect?
Mr. Chairman, I think we'd want to unpack a bit more what programs we want to evaluate, because the way it's written, it would include, I think, juvenile and adult programs from the executive and judicial, and it also could include perhaps other nonprofit programs even separately. And so I think our sense was that this has been on the statutes. We struggle to comply with it. There is results first. Perhaps we could clarify just how we can be helpful to this, while recognizing I think we'll have limitations to fulfilling perhaps the spirit is currently included in statute.
Okay, thank you for that, and I'll have more conversation with you about that offline. Thank you.
Thank you, sir. Mr. Chairman.
Further questions or comments from the committee? Seeing none, thanks for being with us, Mr. Palka.
Thank you, Mr. Chairman. Thank you, committee.
Next up will be Attorney Linkwarder.
Good morning. Can you hear me?
Yep. Good morning, Attorney Woodard. How are you? You have 3 minutes. Go ahead.
Thank you. Good afternoon, Chairman, staff from Senator Winfield, ranking members Kissel and Fishbein, and other members of the committee. My name is Lincoln Woodard. I'm here on behalf of the Connecticut trial lawyers to testify in opposition to House Bill 6465, which is the same bill that was brought in 2019, and I think again raised in 2020, which proposes changes sought by the insurance industry to our collateral source statute. The proposed language here is an attempt to legislatively reverse a unanimous decision of the Connecticut Supreme Court from 2016, the Marciano versus Jimenez case. And contrary to what's being claimed by the insurance industry and their counsel, Marciano didn't change anything, but instead simply held that the legislature meant what it said back in 1986 during Tort Reform 1, when this law was created, that the collateral source statute will only extend to cases where the provider of health benefits has no right to be reimbursed out of a judgment of a third party. Before 86, the common law longstanding principle was that when a wrongdoer hurts someone that necessitates medical care, the wrongdoer is held accountable for those reasonable and necessary medical expenses as determined by a jury, whether or not the provider decided to reduce or forgive a portion of those expenses or due to a lower negotiated rate. The collateral source statute we have was created in derogation or in reverse of this traditional rule and created a statutory scheme. But in the negotiations of all of this, it was only limited to private health insurance payments. And that was because as far as collateral, the Tort Reform 1 involved a whole lot of different reforms, largely restricting victims' rights, and was done sort of on a national level during the 80s. But for private health insurers and this collateral source statute, there were two things done. First, it declared that no health insurer can claim a right of reimbursement so as to protect the liability insurers from subrogation claims in every case. And second, it created a formula for cases where there was no subrogation right to first reduce the reasonable and necessary expenses determined to have been caused by the wrongful act by all amounts paid by the health insurer, but then also to add back in that cost of procuring that insurance so that there is an equitable balance struck there. And the statute was never intended to apply to other collateral source payments for things like disability insurance, and only applies if there was no right of reimbursement, which is exactly what the Marciano court saw and held in their decision. There was a balance of equities at the time of tort reform, and if any changes should be made, then we would be forced to reconsider all aspects of tort reform. And I don't, this is one small piece of a giant bill. I think I'm out of time, so I'm happy to answer any questions of the committee at this time.
Thank you. Let's start with Senator Kissel.
Hey, Attorney Lincoln Woodard. I just wanted to say, great to see you. I have worked on tort reform. I have gotten civil justice awards, and I'm happy to be supportive of your position on this bill. I just wanted to let you know that, and to let you know it's great to see you. Thank you. Thank you,
Nice
Mr.
to see you as well. Thank you.
Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Attorney Woodward, or it's Woodard. Just to be able to frame, what we're actually talking about. There's, I guess we'll take it from a motor vehicle accident matter. There's economic damages and there's non-economic damages. If you could just explain what the difference between the two are.
Sure. Economic losses are if someone gets in a car accident and loses time from work, lost wages, things that normally cost money, or incurs medical expenses, or has to go to the doctor and is billed for medical expenses. Those are the main two, but you can also have future medical needs. You can also have future wages. Non-economic damages are the harms and losses that don't cost money, like the symptoms that you suffer from and the pain.
Pain and suffering, yeah.
Yep.
So what we're talking about here is the economic damages aspect of a matter like that, correct?
That's correct.
Okay. So I'm going to give you a scenario. Plaintiff gets into a motor vehicle accident, and we're going to set the non-economic damages aside because we're dealing with the economic damages with this bill. And they have $100,000 in billed medical expenses. 40,000 of that is paid by their health insurance. We'll say 30,000. That's what I wrote down. So 30,000 is paid by their.
I'm writing this down too. Hold on.
Yeah. And then 10,000 is paid by the plaintiff as copays. Okay.
So 30 by the health provider and 10 out of pocket.
Yes, sir.
Okay.
So now the matter goes to court. Jury comes back, and just dealing with the economic portion of the scenario I've given you, how much money would the jury under the current system award to the plaintiff for economic damages?
So I think from your scenario, you said that there have been bills submitted of $100,000.
Yes, sir.
Is what you said. And if the defendant does not contest the reasonableness of those medical expenses, and those expenses are submitted, then the jury would, and they found them related, they would award $100,000 in reasonable and necessary medical expenses.
And the lawyer would get a piece of that, ordinarily a third, correct?
Only on the judgment at the end. I think you're going to get us to the reductions, but no, it would depend if there are reductions from that.
Okay, and what kind of reductions would occur?
Well, under the collateral source statute, if that was paid by private health insurance, which is what I think you said this was private health insurance, so they don't have a right of subrogation. And then if the defendant were to request a collateral source hearing, at that collateral source hearing, the court would then consider what health insurance paid pursuant to the statute. And then they would also consider, and they would reduce by that amount paid, and they would also reduce by any amounts that were negotiated down from that as well. And then, so under your scenario, I don't know what the, so if they paid $30,000 for the health, for the benefits, it would be reduced to $70,000 for that reduction. But then the out-of-pockets being, you said, were $10,000. So they would end up also getting a reduction for, I'm trying to figure out whatever that remaining offset is that was not out of pocket.
Was my understanding that they wouldn't get a reduction because that was out of pocket. So
Not for the $10,000, but then what happens is you then consider how much did it cost the plaintiff to buy health insurance. And then so for every year of benefits, that would then get added back on before judgment was issued. So if the plaintiff treated over the course of 3 years, it would be 3 years of those premiums that would be added back in.
So it's just within that period of time of treatment from the accident. You certainly, one would have to procure the insurance prior to the accident in order for it to be in effect. And, you know, sometimes we pay for many years before we effectuate, but it's just that period of time of treatment.
It's that policy period. So if the accident was in December and your policy period started in September, you'd get that whole year of the benefits, because the health insurance policies typically run a year.
So then let's add in, we'll solve that question, and we'll say that the premiums for the applicable time were $5,000. What is the ultimate calculation here?
Well, that would be added just the same as the out of pockets would be.
Yes. So ultimately, there would be a deduction for the 30 from the 100, and there would be a deduction for the 5.
No,
Okay, it would be added in.
it would be added back.
Yes.
That's correct.
Okay. So we would be at 75,000 would be our ultimate calculation based upon those figures.
Yeah. Okay.
Okay. So that's the current scenario. I just want to come back and just encapsulate that, that there were $100,000 in medicals, 30,000 was paid by medical insurance, 10,000 was out of pocket by the plaintiff, and 5,000 was the amount of premiums that they paid to get this coverage. They would get an award of $75,000, even though their out of pocket is only 15 under our scenario.
The judgment, you're saying, that would enter?
Yes, sir.
Because saying they're out of pocket for that? No, that's not how the judgment would actually probably be lower because of the offsets under the statute.
Okay, just, you know, because I used to practice in this area, got involved with this sometimes, but and I don't want to belabor this, but I thought we dealt with the deductions and the offsets. I thought we were at 75,000, and based upon the scenario that I gave you, the plaintiff has paid $10,000 in copays. They paid $5,000 for the insurance. So I don't recognize any other out of pockets in my scenario.
And there is no other out of pocket. So that's correct.
So, and the award would be 75,000.
I think so.
Okay. So now should this legislation pass, how would the numbers change, or what would be the ultimate outcome?
So in this scenario, nothing would change because this is private health insurance.
Okay.
In your example, I think you're talking about private health insurance.
Yes, sir. So the individual would still get the 75,000 for economic damages, even though their out of pockets are only 15,000, should this pass.
But I think either way, the result's the same. I don't know that the statute changes your hypothetical because you're talking about private health insurance.
Okay. So would it change if it was public health insurance?
Yes.
Okay. So if this legislation was to pass, how would it change if it was public health insurance?
Because there's a right, well, it depends. If there's a right of subrogation, which there is for public health insurance, then they're going to also include that in these collateral source reductions so that the plaintiff no longer, you get into these calculations where under the current law, you do not get into these calculations. You only consider, because there's a right of subrogation, no matter what that amount is, you end up awarding the amount, the reasonable and necessary medical expenses that are determined by the fact finder.
And just to be clear, that right of subrogation is the right of the insurer to recoup what they paid out on behalf of the insured.
That's correct.
Okay. So applying that scenario to this case, how would the numbers change?
The judgment would be for the full amount of the reasonable and necessary medical expenses for $100,000.
Okay. And that's the present law.
That is right. That's correct.
Okay. And should this legislation pass, how would the number change if it was a public health insurance situation with a right of subrogation?
You're saying if this law were to pass, then you would get into all of these calculations. But the challenge that you'd run into, I can't tell you how you would ever make these calculations in the context of public health insurance, because I've been paying into Medicare throughout my work life. And so has the government been paying into, so has my employer been paying into Medicare throughout my work life. I would have to subpoena federal employees into a collateral source hearing. I just don't even know how you would ever calculate the cost of that benefit. Because under the existing scenario, this is just the liability insurer gets these reductions and they reduce their exposure this way, but the defendant, for us to gain back that cost of procurement benefit, we would now be in calculations that you couldn't do. If you have a self-insured ERISA plan, which also has subrogation rights, you can't tell, they don't have premiums that you pay. So you can't make these calculations. I expect that's one of the reasons why it was kept out, but it really was more just a balancing of all these equities. And this was one piece of tort reform where there was a lot of negotiations going on, a lot of small pieces being parsed out. Disability insurance was kept out of this in all respects in the development during tort reform. So disability insurers can assert a right of subrogation where a private health insurer cannot, or a health insurer like Aetna cannot.
No, thank you for that. I just to condense down, you're saying that the cost of procurement would be very difficult to establish in that scenario?
Impossible, I would say. But
okay. And when you say the cost of procurement, and forgive me once again, I'm not immersed in this. I thought that was the premiums that we talked about.
there was.
Okay. So in the scenario, the first scenario we said is $5,000 for that term. Why does it become more difficult?
Well, so if I'm on Medicare, this Medicare is not something that's an annual policy that has a cost to it on an annual basis. Medicare is something that you pay into throughout your work life, so that, and you're not paying for your own benefits, you're paying for the benefits that are being paid out to someone else right now. So it's just the reason that's so simple in the context of private health insurance is because there's a cost that you pay. I buy health insurance and I pay a lot of money for that health insurance for me and my family every year. And it's an annual policy. And so if I'm treating related to a case for 1 year, I get the cost of the procurement of that benefit. And in your scenario, I think you're talking about, with the $100,000 of treatment, that all took place in 1 year, in one policy period. But on Medicare, in the context of Medicare, I'm paying Medicare right now every year as part of my contribution, but that's going to people that are collecting on helping to pay those that are collecting those benefits now.
So, and I thank you for that. I don't want to belabor this, but I thought that we were talking about the premiums from the time of accident per se until the time of determination in the initial scenario. How do we now get to, in this other scenario, the lifetime of the plaintiff paying into Medicare? How did we get to that?
Because if I get in a car accident, I'm not on Medicare at this time. So if I get in a car accident tomorrow and seek treatment, then my health insurance that began October 1 of 2020 is going to run through October 1 of 2021. That health insurance paid for that benefit. So now the tort feed, so at the collateral source hearing pursuant to the statute, if I incurred a $100 bill for that treatment that I just got, I would have the right to have it fully offset, and the jury would award me the full $100. I would get a judgment for the full $100 because the cost of getting that benefit was I am entitled to the full year of premiums. But under the scenario of Medicare, what's the cost of Medicare for me? What's the cost to procure that benefit? Well, the federal government pays some through tax. We all as taxpayers pay it. I contribute to it, but I contribute to the whole giant system. It's unworkable to do those calculations with any kind of public health benefit.
Understood. And I thank you. And thank you, Mr. Chairman.
Thank you. Representative Blumenthal.
Thank you, Mr. Chair. And nice to see you, Lincoln. How's it going?
Nice to see you as well.
Thanks for being before us today. I had a couple questions for you. First of all, following on Ranking Member Fishbein's question or line of questions, it seems like figuring out for a plan with subrogation, figuring out after the fact at the collateral source hearing, what the offset would be and kind of the numbers on all this would be very complex and confusing. I'll just say I was confused by the question and answer there. Would you say it would be complex to try to figure out who owes what at the end of the day?
Incredibly, I think impossible. Because even we talked a lot about the public insurance, but if you take the self-insured, a lot of large companies now are self-insuring. They take a pot of money and they set it aside and they hire a company to administer that plan. And they do that because the federal law gives them a right to seek reimbursement. So that's different than the Aetna insurance I buy in my small business. So in that scenario, what's the cost of that health benefit? It's based on, again, a large pooling of monies and estimates and risks for the year. And there's really no good way to calculate that. They've decided not to go buy insurance premiums every year that we can identify. They've decided to self-insure, and that's, again, there's no way to calculate that. I mean, you just couldn't do it.
Okay, and as we all know, most cases in our civil system, well, the vast majority end up being settled before trial. This legislation would only affect cases after or that go to trial. But would it be fair to say that this legislation and the complexity and unpredictability of damages that it would create, would that create difficulties or challenges to settling cases?
Yeah, I think that there's no way to, if we all know how things work at this point, and if with these types of changes, how these hearings would go and how these costs are going to be calculated, we're going to be subpoenaing people who are trying to get federal records into evidence in these post-collateral source hearings. And again, the insurance company's job is to try and pay as little as possible for when someone's injured. And this whole notion that these are phantom damages, as I saw in some of the writing, or these are reasonable and necessary medical expenses that are determined by a jury, and the defendants have the right to contest those, and oftentimes do. And so once that award, the amounts of those bills, if they think a doctor's overcharging when they submit their bill, they're entitled to defend that. And this really flips everything on its head and makes it seem as though the person who gets hurt and injured, is just getting this great windfall. They did nothing wrong, and that's why the original common law rule was in place to, it's an equitable balance as part of a lot of tort reform is balancing of equities, and the old law was fair in that it's a balancing of rights in favor of the person who did nothing wrong to cause the harm.
So it seems, from my experience and from talking with other attorneys, and you've kind of discussed this, bills are often used as a yardstick for damages. The predictability, I think, lawyers find often makes it easier to settle cases because everyone has an idea of what the case might go for at trial. And I think this could introduce some serious unpredictability that could actually prevent cases from settling and introduce inefficiencies into the system. I wanted to move to a subject that you kind of addressed in your answer, which is, are the bills that physicians submit legitimate?
Presumably so. We get the bills. We request bills as part of every case where there's medical expenses incurred, and we don't contest those, but oftentimes the defendants will take issue with them.
So as you mentioned, they have an opportunity to do that, but there's no indication that physicians are engaged in widespread fraud in their billing practices.
No.
And I'm sorry, I didn't mean to interrupt you.
No, I just said not that I know of.
Okay, not that I know of either. I would certainly hope not. So if that full billed amount, first of all, if the plaintiff doesn't have health insurance, would they have to pay that full billed amount?
Yes, and you raise a good point there. I mean, I've had cases within the last year where the person was uninsured and the hospital bill is the same amount that we submit and they're required to pay it. And maybe they can call up and say, we'll pay over time, but the hospital's expecting to get the money that they're charged because the individual can't negotiate a lower rate, the same as an entity like Aetna or certainly Medicare that just pretty much declares what they're going to pay.
Okay, and so you mentioned this, health insurers negotiate on behalf of their of their policyholders. Fair to say?
Correct. Yes.
Okay, so is it fair to say that the insurance industry, on the liability insurance industry, in advancing this bill, is seeking to get the benefit of a patient getting health insurance, and also the benefit of that health insurer's work in negotiation on behalf of their patient?
That's right. That's exactly correct. And I mean, even under the existing tort reform laws originally introduced, the liability insurers benefit because part of that whole bill is that the Aetnas of the world cannot reach back and say, we want to be paid back by the liability insurer for the defendant for those health bills. I mean, that was a big benefit that liability insurers got by not allowing private health insurers to seek reimbursement.
That raises an important kind of equitable point to me, because, you know, it seems to me that the last entity to benefit from this negotiation should be the insurer for the wrongdoer. If anything, I think, you know, maybe the physician should be paid back the full amount of their bills by the liability insurer, but it certainly shouldn't be that the plaintiff or the health insurer should be essentially, you know, working for free for the wrongdoer's health insurer or the wrongdoer's liability insurer. Do you have any comment on that?
Yeah, no, I think that's precisely correct. I mean, in fact, the bill that's proposed here goes much further than just trying to include those with rights of subrogation into this bill. It also says, you know, if I, as the injured victim's attorney, have negotiations with the self-funded ERISA plan, let's say, and negotiate with them based on their language and do a lot of work, which we often do, to negotiate a lien down for some reason, based on a number of factors. They want to take they want to grab onto all that benefit too, as well. That's how the bill's drafted, so that if you successfully negotiate a lien down on behalf of your client, oh, well, then, you know, the wrongdoer doesn't have to pay, gets to take advantage of that as well.
And I guess that would probably decrease the incentive of you to negotiate on behalf of your client, in addition to kind of having the wrongdoer free riding off of your work.
Well, that's right. I mean, there wouldn't be, but.
So that seems problematic to me as well. In your discussion with the ranking member Fishbein, you discussed what the jury would award if presented with certain bills. Is there any requirement that the jury award any specific amount of economic damages?
No, they evaluate the evidence. They determine whether a medical treatment is related to the wrongdoer's negligence, and then they decide whether there's a reasonable and necessary medical expense associated with that. And that's the decision that they make when awarding it. And then you have to, you know, if you're at trial and that's going on, at the end of the day, you also have to consider how much liability insurance there is to cover those losses. I mean, that's something we get into all the way along, and can result in huge unfairnesses to the injured party where there's inadequate coverage.
So juries already have a crack at reducing those bills if they want to, I guess.
Correct.
And so I guess what the insurance industry right now is asking for is to get a chance to reduce those bills in a way that we really can't understand, based on your testimony about how you would calculate them. Basically, after the jury's already decided what the bills are worth and out of the presence of the jury. Would that be a fair characterization?
Yes. I mean, they want to take all of the benefits of the negotiated rate, and then, you know, what would be impossible is for us to determine what's the fair cost of the procurement of that insurance and how to add those back on, as we do with the private insurance.
Appreciate that. So you talked a lot about how tort reform was pretty heavily negotiated.
Yes, well, successfully by the insurance company more than anything, but yes, it was a lot of negotiations.
So, one of the advancements on behalf of the insurance companies in that negotiation was transitioning from a joint and several liability system to an apportionment system, is my understanding. Could you explain what the difference between those concepts are and how it works in practice?
Yes, I'll try. The joint and several liability would mean that that they are going to share if you're found responsible, you're going to be fully responsible jointly with your other responsible parties. And the apportionment statute allowed sort of a pie chart of negligence so that there are percentages broken up, and that the jury determines what percentage of fault rests with what person. And if it falls on the plaintiff, the notion of comparative negligence was established as part of Tort Reform 1, which says that if the plaintiff is more than 50% at fault, he or she recovers nothing can't recover from a wrongdoer, even if they're 49% at fault.
Okay, so I appreciate that answer and all your answers. That seems like it creates really deep unfairness to someone who's potentially been wronged and can only get part of their injuries compensated, even if there are people who've been proved at fault. So, I think if we were going to reopen some part of this, like the collateral source rule, it would make sense to me from an equity standpoint to think about going back to that joint and several liability standard, because if we're going to open up one end of it, then there are already deep unfairnesses in the system that has been negotiated, and everyone kind of balanced it out in the negotiations. And so I think there are significant issues there. So I appreciate all your answers and your testimony and you being with us here today. And thank you, Mr. Chair.
Thank you. Rep. Conley.
Thank you, Mr. Chair. I wanted to build on some of the things that Rep. Blumenthal was talking with you about, Attorney Woodard. It's good to see you today. I wanted to talk a little bit. I was on a couple meetings, so I don't know if some of these questions were brought up by the proponent of the bill, but I did want to talk a little bit about minimum policies. Attorney Woodward, what's the minimum motor vehicle policy in our state right now for coverage?
It's $25,000 per person and $50,000 as per incident. That's the minimum as a current incident.
So for folks watching at home, if we have a vehicle where 4 people are in the vehicle and they get hit head on, all 4 people would have to split that $50,000 as a maximum coverage?
Yes, it's one of the most difficult conversations we have in representing individuals. We've got, within weeks, I've had conversations, a conversation in particular with a family who someone died in a car accident, was hit by a driver who has the minimum policy, and there's no more insurance out there to cover this person on a wrongful death claim of someone in their 50s who did nothing and was hit head on. There's inequities all over this system, and that certainly is one of the hardest ones to deal with for someone who never thinks they're going to need to take advantage of this system, because nobody ever thinks this stuff is going to happen to them.
So Attorney Woodward, have you heard or been involved in cases with folks who have had catastrophic damages and limited coverage or minimum coverage available?
Many times, yes.
And oftentimes, if that person, let's say one ER bill could be more than the coverage available for that claim, correct?
That's correct. Yes.
So in those cases, as an attorney who represents the injured person, don't you do your best to try to get that family or that injured person whatever recovery is available in those limited policies?
Yes, that's correct. And I think that's really one of the reasons why the actual statute doesn't, we have what we call an anti-subrogation statute for private health companies, so that they don't swallow up cases like that where there's inadequate coverage.
Because for that family or that injured person who could be paralyzed or, God forbid, deceased, there's a one opportunity for coverage, and it may only be as low as $25,000 or even lower if there were multiple injured parties in that collision. That's
correct. It happens all the time.
Now, when you're negotiating a lien with a carrier, don't often folks represent to have ERISA liens that actually do not have ERISA coverage liens?
Yes, we get those letters all the time. There's a whole process that you go through. I think many of us in doing a lot of this work have a standard letter. There's certain collection companies that will send them out indiscriminately across the country because some states allow private health insurance plans to collect. They don't have a statute in place, although the majority of states do not allow for that type of collection, but they'll send out the letter hoping that somebody will just agree to pay the bill back. Happens all the time.
So often your staff are spending an exorbitant amount of time verifying if these liens are even valid under Connecticut state law to start with.
Correct. And it's not an easy thing to go through to figure out whether it's actually a fully self-insured plan that has entitled under the federal laws to reimbursement, or whether they're just bluffing. Constant battle.
And then once it's determined to be a law, if there's limited coverage or a valid lien, if there's limited coverage, then you do your best to try to get the family of the injured person some recovery, especially in these cases where there's very little to go around, correct?
Correct. And
passing this law as written would further impede the abilities for injured folks to collect money in limited coverage cases, correct?
That's correct.
I wanted to talk about family or multi-person health insurance coverage. So a lot of us, I think on this call, probably carry health insurance for our families, where you might have a spouse or children under that same policy. You're aware of those situations?
Yes.
And you as an attorney, you don't always have permission to speak, and you don't always represent the person who holds the health insurance coverage. Is that correct?
That's correct, yes.
So in our state, you can be under your parents' coverage up to age 26.
Yes.
So you could represent an adult under age 26 and not have any ability to obtain the payment records from the parent who holds that policy.
That's correct, or especially if it's through their employer, it's even harder.
So you would be, if this law passes as written, faced in a position in a post-jury motion before the judge trying to obtain records for a non-client who holds the health insurance and their employer, neither of which you'd have permission to directly speak to. Is that correct?
Yes, more often than we are now, put in that position.
And then if you don't have permission to speak to the employer, to the holder of the health insurance coverage, the non-client or their employer, how would you be able to obtain these records?
We'd have to subpoena them probably, and then face objection from a lawyer that would come in to deal with the company, or if it's a family. I mean, I think normally where we would see that would be in the context of the person's employer not wanting to provide that information.
And we know some family situations are easy to understand, and some family situations are quite complex.
Very much so.
And especially with custody issues, and some families do not speak, unfortunately, even if they are providing the health insurance coverage for other family members.
Right, part of a separation agreement or something to that effect.
So that this would involve more court resources and possibly involve some connection with family court in those cases where there is difficulties between divorces or minor children involved.
Yeah, if we're to the point of having a verdict, it would certainly be happening more than it comes up currently, because it would
So
be.
this could, so these matters can involve multiple post-trial hearings in the civil court, subpoenas, judicial marshals, and possibly even interaction with the family court system or other areas for minor children involved in accidents, correct?
Yeah, I think so.
I also wanted to talk a little bit about, I'm sure you're familiar and probably pay DAS liens on a regular basis.
Yes.
So those would be accident-related injury costs for folks who were on Husky or other state, if state health insurance paid for their claims.
Yeah, if it's related medical benefits, it's treated slightly differently than the other types of DAS liens.
And I'm sure your office and many offices probably have standard letters that go to DAS on a regular basis where they quickly respond about charges for accident-related medicals, and those negotiations happen on a weekly basis at your office, correct?
That's true, yes.
How would that injured person who was getting Husky be able to show their tax payments to offset that Husky benefit?
Well, it's the same as the Medicare problem. It's a calculation that just can't be done. And presumably the insurance company would just like to say, well, you don't get to put any evidence of the cost of procurement of that benefit, but that's, again, that's just a further windfall to the defendant in that circumstance. And I don't know, I think it's an impossibility to make those calculations.
That's all the question I had for you. Thank you. Thank you, Mr. Chair.
Thank you.
Thank you. Seeing no further questions, Link, always good to see you. Thanks for being with us today.
Thank you, Mr. Chairman. Nice to see all of you.
Next up will be Attorney Mike D'Amico. Attorney D'Amico.
Okay, can you see me?
How are you, Mike? Go ahead.
All right. Good afternoon. I'm calling in from the sunny state of Florida, so I'm in my casual garb, so bear with me as I take a break from a vacation. But good afternoon, Chairman Staffstrom, Chairman Winfield, ranking members Fishbein and Kissel, and other members of the Judiciary Committee. I'm here in opposition to the same bill that Attorney Woodard just spoke about, 6465. I've been doing this for 35 years. I'm co-chair of the General Tort Committee of the Connecticut Trial Lawyers Association. I've been representing injured parties due to negligence for a long, long time. I'm not going to belabor the points that Link made. I'm happy to answer questions, but I did want to just mention in summary, because I did submit written testimony. This was a complex negotiation back in 86 or 87. I'm dating myself, but it was at the beginning of my career. And insurance, business, trial lawyers, and other interested parties participated. Joint and several liability was abolished, as we've spoken about. In its place was an apportionment scheme. It's quite complicated. Certain immunities were granted, and the collateral source rule was abolished in part as to traditional medical insurance plans, but not as to lien plans or plans of subrogation. The Marciano decision was my case. A quick summary: the gentleman was injured in a car crash. He was an employee of UPS. UPS has an ERISA qualified self-funded medical plan for which there should be no reduction in economic damages. The trial court heard evidence after verdict, thought that there should be at least some reduction. It went up to the Connecticut Supreme Court, and the Connecticut Supreme Court disagreed. And in that decision, the Connecticut Supreme Court made it clear that the legislature meant what it said when it passed the tort reform bill. It was a balancing of equities. And in that balancing of equities, there are some cases where folks may say that the result is a double recovery or a windfall. I don't agree with that. Anytime somebody's health has been taken away through negligence, it's never a windfall. The pandemic, if it's taught us anything, has taught us that our health is the most important thing that we have. And those that injure us through negligence should not receive the benefit of those collateral sources that we have been wise enough to purchase or that we've earned through our employment related benefits. There were some examples of a drunk driver, let's say, somebody who's negligent and kills someone. There's only a $25,000 policy. That's a tragic situation. It's inequitable when you have someone that's deserving of substantial monetary justice and receives only $25,000. This kind of a bill, assuming it was a lien plan, would result in a further reduction of that $25,000 in terms of a award to that tragically, in that tragic situation, which is ridiculous. So I'm not going to belabor all the other testimony, but I'm happy to answer any questions and try to put things into context for anyone that has questions.
Thank you, Attorney D'Amico, and certainly I think this committee appreciates when we hear that a court says we mean what we say. So that's refreshing. Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Attorney D'Amico. Just briefly, because we heard a lot from your colleague on this issue. I'm just trying to get clear. Is it your position that the trial court in your case just ignored the language of the statute, or there was ambiguity? Because I haven't read the case, and I'm just going by what you're telling us.
I think what the court did was they read ambiguity into the statute that the Supreme Court said was clear, but I'm glad you asked the question because I did want to make a point. A self-funded plan is not the same as a traditional major medical plan. As Link had mentioned, it's easy to calculate the premium cost for a traditional major medical plan. You just ask the insurance company how much the premium was, so you can find out how much the employer contributed to that set premium and how much the employee contributed to that set premium. You add them together and you know what to deduct. This Marciano case involved the UPS, which has a self-funded plan. And so in order to present evidence at the collateral source hearing, we had to go through incredible and lengthy efforts to ask UPS what the administrative costs were to the provision of that benefit to this employee. It was a monumental undertaking, and it turned out that there were about $58,000 in UPS administrative costs in order to provide that benefit. So what the court did was they added those administrative costs plus the lien amount together and then deducted it from the economic damage award, which in that case consisted all of medical bills. But if this bill were to pass, in every single collateral source hearing post-verdict, employees of businesses would be subpoenaed into court. They would essentially have to set aside a department to respond to lawyers' requests in terms of how to calculate these types of administrative costs. Some of these ERISA plans, by the way, are pooled plans through various employers, not just one employer. UPS was a little easier because it's one employer, and that was a nightmare. Some of them are pooled funds for multiple employers. Some of them have what they call stop loss insurance, where the employer is only responsible up to a certain amount of medical bills, and then stop loss insurance kicks in. So then you have to not only calculate the employer's administrative expenses, now you have to figure out what the stop loss insurance premiums amount are. I mean, it's just an incredibly monumental undertaking just in the ERISA situation. Forget about Medicare and Medicaid. Those are ridiculous. I mean, as Link said, it would be impossible. The government would have to essentially set up a staffed office to respond to lawyers' requests and be subpoenaed to hearings, if it could even be calculated. I mean, it would be ridiculous.
Well, I thank you for that. And I think I would have objected a bit ago, move to strike non-responsive. But with that in mind, I just want to come back to the question that I asked, and that was about the ambiguity, because I'm concerned if a trial court, just took the language of the legislature of the statute and said, I don't care, I'm going to do my own thing. And the Supreme Court said, it's pretty clear, legislature meant what it meant. Or was there an ambiguity and the Supreme Court resolved that ambiguity, and now that's why we got where we're at? I'm just trying to figure out which one is the scenario.
I think what the court did was the court listened to the argument of the defense and believed in her mind that the statute was ambiguous. But the statute is clear. It says that there is no right, there's no reduction when there is a right of subrogation. And so the Supreme Court simply said that the statute is clear. We don't need to go through legislative history. We don't need to do any of that because the statute is clear. The statute clearly says there's no reduction when there's a right of subrogation. Had the legislature intended to say there's a partial reduction, if there's a limited right of subrogation, they could have easily said that, but that's not what the legislature said. It said that there's no reduction where there's a right of subrogation, and for good reason. I mean, this was a balancing test. And so there was give and take on both sides. I mean, the collateral source rule, as you know, back in common law said you don't get the reduction for any benefits that the plaintiff was wise enough to have purchased. If you're the wrongdoer, you should pay for what you did, and you shouldn't get the benefit of that. There's a strong public policy to deter negligent conduct, and the reason that there was no reduction in common law was to maintain that deterrent effect, which was based on good public policy grounds. Tort reform essentially turned that public policy on its head based on the insurance company's wants, but then drew a line and said, well, we'll give it to you for traditional major medical plans, but we're not going to give it to you for plans where there's a right of subrogation or lien right. So we'll give you some, but we're not going to give it all. It was part of a negotiated process, no different than the abolition of joint and several liability and this installment of apportionment schemes. I mean, it was a complex negotiation. And there's other things that we didn't talk about. In the example that you gave to Link, if there had been comparative negligence, then that economic damage award for medical bills would have been reduced by the plaintiff's percentage of comparative negligence. But if this bill were to pass, there's no similar reduction to the right that the defendant would have to reduce those economic damages further by the amount that's not subject to subrogation or lien. That wouldn't be fair. I mean, you should also reduce that by the percentage of comparative negligence that the rest of the economic award was reduced by. I mean, this is a complex process, is what I'm suggesting. And all these arguments were considered, they were dealt with, and it was a behemoth effort that no one ever wants to revisit. I certainly don't want to ever revisit it. And I'm sure that none of you there will ever want to revisit it. There's just not simple answers to these questions. It's complex, but I'm doing my best to respond. But there is no ambiguity in the statute.
Okay, thank you, and thank you, Mr. Chairman.
Yep. Representative Baudet.
Thank you, Mr. Chairman, and I apologize. I've been jumping back and forth between environment, transportation, and judiciary. So if I'm repetitive at all, I apologize. Good to see you, Attorney D'Amico.
Good to see you as well.
I know you just went through some of the historical happenings of Marciano, but who was the trial judge?
Swenton, Judge Swenton.
If you could just kind of give us the historical purpose of the collateral source rule in a nutshell from your perspective.
Yeah, so I mean, for more than a century, it may have been 2 centuries. I'm not a history teacher, but it was a long darn time, I can tell you that much. At common law, the rule was that if you had another source by which your medical bills were paid, it didn't matter if your parents paid them if you were a child, for instance, or if insurance paid them, or if a neighbor who liked you gratuitously paid them. It didn't matter how those medical bills were paid. The wrongdoer was not allowed to reduce their responsibility because you were fortunate enough or wise enough to have a medical plan in place, or someone was willing to pay your medical bills for you. If you were the wrongdoer, then you had full responsibility for the damages that you did, including all the economic damages, all the medical bills. And we want it that way because we want to deter negligent conduct. We want to make sure that if you're negligent, that you pay the price. And so at common law, that's the way it was until tort reform came about in 86 and 87.
So you, as you've gathered from the questioning and the point, I mean, you can see what Marciano's trying, or this legislation's trying to do. What, if anything, would you recommend to us to try and do to address the concerns that the proponents of this bill are trying to address, if anything?
Well, I mean, if we're going to revisit tort reform, then we have to revisit all of tort reform. I mean, you can't just pick one piece of it. I was trying to think of a good analogy, but my brain doesn't work as good as it used to. But it's, you know, somebody makes a deal. I don't know, think of any deal you can think of that has multiple give and take in it. And then you make the deal, you shake hands, the legislature passes the bill, and that's the law. And then one of the interested parties in that deal comes back years later and says, "What? Hold the phone. I want to take back one of those things that I agreed to way back when." Well, nothing's changed. In other words, absolutely nothing has changed since that bill has passed, except the want of the insurance industry. And it's just not right. I mean, you can't broker a deal and then come back when nothing has changed and say, "Oops, we want to change it."
And just to clarify, there was some questioning from other litigators. You know, one of the things I did for my policy is I made sure I've got a huge amount of UM/UIM coverage. So in your catastrophic cases, if I got hit by a $25,000, a person insured with 20 grand or 25,000 bucks, I can tap my UM/UIM coverage, correct?
You can. It's a rare instance where somebody has an adequate policy for more catastrophic injuries. I mean, but yes, you can. You can certainly purchase underinsured motorist coverage, and that is a way that you can protect yourself. Yes.
So I would encourage everybody that's watching this hearing to check your UM/UIM coverage at the very least. But all right. Thank you very much, Mr. Chairman, for your time and indulgence. And thank you, Mr. D'Amico. I appreciate you.
Good seeing you. Stay well, please.
All right. Thanks, guys. Anything further? Seeing none. Attorney D'Amico, thanks as always for being with us.
Thank you. Good to see you. Stay well.
Next up will be Barry Hawkins, Attorney Barry Hawkins from the Black Rock section of Bridgeport. Attorney Hawkins.
Thank you very much, Chairman Zastrom, Chairman Winfield, Ranking Member Kissel, Ranking Member Fishbein, and members of the Judiciary Committee. As the House Chair indicated, I am Barry Hawkins, a resident of Bridgeport, Connecticut, of counsel to the firm of Shipman and Goodwin. And I am a past president of the Connecticut Bar Association, and wearing another hat, or two other hats. I was former chair of the real property section of the Connecticut Bar, for whom I am speaking today, and a member of the Uniform Law Commission, the group which drafted the statute in front of you, the Uniform Commercial Real Estate Receivership Act, UCRERA, I'll refer to it. UCRERA was drafted in 2015 by the Uniform Law Commission, and is being proposed throughout the country to provide a comprehensive statutory framework to deal with the foreclosure and the appointment of real estate receivers for commercial property. The vast majority of our states, at the time of the passage in 2015 by the Uniform Law Commission, there are 53 jurisdictions in the United States, the 50 states, the District of Columbia, U.S. Virgin Islands, and Puerto Rico. Of those 53 jurisdictions, only 8 of them had a statutory framework for the appointment of a commercial rent receiver. The other states did not. Since the passage, 10 states have adopted UCRERA to provide themselves with a statutory framework, and 3 others are now considering it. There may be more introductions later this year. Why are the states interested in having the statutory framework? The answer is fairly simple. The vast majority of cases where a rent receiver is needed for commercial property involves a situation in which the borrower, the developer of the property, owes money to a lender and has not been able to repay the debt on a timely basis. And therefore, the lender seeking to recoup its loan has brought an action to foreclose the property. As we know, with the sad commentary of the last year, and even before that, it takes a very long time in a judicial foreclosure state to go through the process of foreclosure. In this last year, it's been almost impossible to do that. And in the meantime, what happens to the rent, which has been assigned to the benefit of the repayment of the loan? If there is a statutory framework for the appointment of a commercial rent receiver, the rent gets paid to the receiver. The receiver ensures that the loan proceeds or that the rental proceeds are devoted to maintaining the property, keeping it in a safe and a manageable condition to the benefit of the tenants of that property, its neighbors, the municipality in which the property is located, and ultimately, with the funds left over, to repay the debt. So that's the primary purpose and primary vehicle by which the lender gets repaid its rent. When it's not a statutory framework, it's left to the discretion of the judge, and that can vary from judge to judge, even within the same courthouse. We have a system in Connecticut of common law and equitable rights to have a rent receiver appointed, but it is highly subjective and under the discretion ultimately to the court and to a development of common law decisions which vary all over the lot. The benefit of having a commercial receivership statute is that you have uniformity among the various jurisdictions of the state and predictability for the lender, for the tenants of the property, for the municipalities in which it's located, ultimately to the benefit of the state. For those reasons, we very much urge you to pass HB 6356 for a commercial rent receivership statute in Connecticut.
Thank you, Attorney Hawkins. Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, sir.
Afternoon.
I will share that I'm involved in putting together a similar action involving a trailer park. And am I to understand that this statute would supplant the current procedure in toto that we have in our statutes?
Well, it depends. If it's if the trailer park, I'm not actually sure of the classification. It sounds to me as though what I think of a trailer park, that it's going to be residential, and that the property, if they're owned individually, would be 1 to 4 family residences, which were outside the purview of the statute. If it's a property owned where all the trailers are owned by one developer or an entity, and that it is a commercial transaction involving more than 4 households, it could be a commercial property, in which case the statute would supplant the present system that we have.
Okay, I thank you for that information. That's
You work at 5:30, come home, we'll get in the car and go. Does that work?
I thank you for that information. That's helpful. I do agree. I've had to reacquaint myself with this whole area, and there does appear to be a lot of discretion in the present. So, I thank you for bringing this to us and for your presentation here today. So, thank you, Mr. Chairman.
You're welcome.
Thank you. Attorney Hawkins, just super quick. I know there's been some testimony submitted on this bill by the judicial branch. I don't know if you've had a chance to take.
I have not seen that yet.
Okay. They're asking that the effective date be kicked out a little while to allow for some conforming rule changes. And also it looks like some clarity around the appointment of the receiver and what the court's role in selecting the receiver is. if you don't mind, just when you have a chance, take a look at those comments and email me or the committee administrator with your feedback on the judicial branch's comments so that we can make clarifying edits if we need to as this bill moves forward. I'd appreciate it.
Yeah, no, I'd be glad to do that. It sounds just from your description of it that those are things that we should be able to work out.
Okay, great. I thank you and the Uniform Law Commission, as always, for your work and volunteer work, really to help us as a state in dealing with some of these issues that, while they don't always make headlines, news headlines, are fundamental to the operation of government and the efficiency of our court system in the state. So I appreciate it.
You're very welcome.
Next up will be Representative Devlin.
Hi.
Good
Can you hear me
afternoon,
okay?
Yep. Good afternoon, Representative. You have 3
Sorry, I
minutes.
have dueling legislative events, so sorry about that. Thank you, and thank you, Chairman, and our ranking members for hearing House Bill 5598. So this piece of legislation, which deals with the property owner's liability for the expenses of removing a fallen tree or limb, is not something new. It's not something new to this committee. You have passed it out unanimously in the past, as it was offered by our former representative, Camillo. Essentially what this bill would do is it's between private property owners. And if a private property owner has a tree that is diseased or is to fall, and with proper noticing, which is outlined in the bill, does fall on a neighbor's property, whereas today it's the individual of whose property it falls on to take care of that. What this does is make the liability the responsibility of the individual that owns the tree. It does not include conservation lands. It protects that. It protects water companies. It protects municipalities. It's really between private property owners. So I think you're familiar with the issue. I'm going to leave it at that for now, so I can take any questions that you have and respect your time.
Thank you, Representative. I know we have a couple new members of this committee, but certainly those of us who have been around for any longer than a session or two are fortunately or unfortunately well familiar with this bill and its substance. I was really hoping that First Selectman Camillo was going to join us today for the hearing. It just doesn't seem fitting having this bill before us without seeing his smiling face here with us, but
he didn't want to, but he did submit testimony.
All right, well, we appreciate you filling in for him, as the case may be. Representative O'Day.
Thank you very much, Mr. Chair, and thank you, Madam Deputy, for your testimony. Chairman, you kind of stole my thunder with the Camillo bill. As I understand it, this is passed out of judiciary a couple of times, and in fact, on the floor of the House. Is that correct?
It's passed out of the floor of the House at least twice. It passed the Senate once. It was vetoed by Governor Malloy, I believe in 2014. And at that point, it was because there wasn't a provision to have a licensed arborist involved in the process. So that has been addressed. The bill most recently, I think, went through the committee in 2019.
It sounds like a consent calendar type bill to me. Thank you very much, Madam Deputy.
Thank you,
Mr. Chairman.
Thank you. Yeah, the only thing I would add on that, Representative Devlin, is we do have testimony from the Connecticut Forest and Park Association that wants us just to make sure we're clear enough as to limits of the state's liability under this. So perhaps caucus staff can take a look at that and get back to LCO on it. That would be appreciated.
And along those lines, Mr. Chairman, if the committee might consider another aspect to this bill, and Rep. Turco and I know you're going to hear from him a little bit later, have been talking about this together. And that has to do with state trees. And I know there is some concern about that, but here's something that maybe you could consider. Today, if a state-owned tree falls on your property and the state comes out and says, yep, that's our problem, we own that. What is required then is that you must go pay to have that tree removed and then go through a process to get reimbursed by the state. So theoretically, you could be out up to $10,000, depending on the size of a tree that may have fallen. And there's no dispute about who's responsible. It's just that because the state doesn't want to assume liability for going onto your property, you're required to pay for it. But if there's a way to have the state pay directly so that you're not out of pocket up to $10,000 waiting for this process and the state to reimburse you, it doesn't change, who does what. It just really helps the individual, and from a cash flow perspective, not be out. And I did speak to Mr. Hammerling, and I know he has endorsed this bill in the past.
All right, thank you. Further questions or comments? Seeing none, thanks for being with us.
I appreciate it. Thanks very much.
Next up will be Amy McLean.
That's my God. I mean, she's not,
Is Amy, Madam Administrator, not with us? Okay.
She's not here.
Okay, we're going to move on then to Representative Turco of Newington. Representative, good to see you.
Good to see you, Chairman Staffstrom and Chairman Winfield, Ranking Members Kissel and Fishbein, and honorable members of the Judiciary Committee. Thank you for having me. I am State Representative Gary Turco. I represent the 27th House District, which comprises most of the town of Newington. And I'm also here to testify, as Representative Devlin just did, on House Bill 5598, an act concerning a property owner's liability for the expenses incurred when trees or tree limbs fall on an adjoining owner's real property. I love that this bill is starting out as a strong bipartisan bill. I like Representative O'Day's thinking. Maybe we should just do this in consent, sometime early in the session and get it done, because as was stated, this is past your committee, it's past the House, it's past the Senate. It's even, it's gone all the way to the governor's desk, former Governor Malloy, where it was vetoed. But that was because of some environmental concerns, and as Representative Devlin said, there have been changes now to the bill that have made it better and I'm not sure those concerns were even founded back then, but now I certainly believe they've been taken care of. We're talking about damaged trees, not taking down any trees that are healthy. And because you have new members of the committee, let me just quickly explain why I'm supporting this bill. I'm really coming here on behalf of my constituent, Lisa St. Germain, who brought this issue to my attention. And she's going to be testifying shortly because she can share her personal story. So Lisa lives here in Newington, and the surrounding neighbors of hers have lots of big trees. And these trees, they are unhealthy trees, and limbs from these trees and the trees themselves continuously have been falling on her property, and it's costing her thousands and thousands of dollars for the cleanup and then the damage it does to her home with deductibles and to fences, to pools, and everything that it's damaged on her property. And the current law, Connecticut state law, says that it's not the person where the trees are located, her neighbors who have the trees on their property, it's Lisa's responsibility. So she's just being a good homeowner and taking care of her property to the best of her ability, and she's having to pay out of pocket thousands of dollars when these trees fall onto her property. So it's just not fair. And what House Bill 5598 is seeking to do, it's seeking to create a process that is going to be more fair, that it's going to involve professional arborists who are going to determine the tree's health to see if there is a risk. And if there is a risk, that neighbor where the tree is located will have the ability to either take down that tree in the worst case scenario, but possibly they just have to cut back some limbs and do some things to ensure that if the tree falls or if limbs fall, they don't damage their neighbors' properties. Because a lot of times now too, without having a process like this, if this situation does incur, it causes a lot of ill will between neighbors and it causes costly civil legal disputes. So I know, and I'll wrap this up, Mr. Chairman. I know we have a lot of pressing issues this legislative session, and this committee has a lot of important work that it's doing. And we're in the middle of a pandemic, and I know this can be seen as an issue that's just not urgent, and we'll worry about another time. But again, I think it's an easy one we can get through. It is impacting constituents in all of our communities, and we can save them thousands of dollars, and we have good bipartisan support.
Thank you, Representative Turco. I think you had most of us until you said you're going to cut down on the amount of billable hours for lawyers in the state. And I think that's where a bunch of members of this committee, you lost us, but that's okay.
I'm worried about that, but I know we like to do the right thing, right?
Representative Blumenthal.
Thank you, Mr. Chair, and I'll be very brief. Thanks, Representative Turco, and my thanks to Representative Devlin as well for bringing this bill forward and for testifying on it. I've supported it in the past. I agree. I think it's important. You know, as a homeowner, I've dealt with situations like this. Luckily, my neighbors are very nice, and we were able to come to solutions by talking to another. But you know, that's not always the case. Some people don't like their neighbors, or their neighbors don't like them. And so it can create huge problems, and trees can be dangerous if they're diseased. So, you know, Robert Frost said, good fences make good neighbors. I think maybe improving our laws about the accountability for diseased or dead trees could make better neighbors in Connecticut as well. So thank you for being here. Thank you for supporting this bill. And I agree, you know, maybe we should consent this one.
Thank you, Representative Blumenthal.
Representative Godfrey.
Thank you, Mr. Chairman. I appreciate it. Representative Turco, I've been on both ends of one of these. In Hurricane Sandy, one of my neighbors, very large Norwegian maples, which are an invasive species, by the way, and fall down a lot in Connecticut, fell across my land, took out my garden shed and a good chunk of my my garden. My homeowner's insurance covered every penny of it. All I had to do was contact them. They came in, they paid for the tree removal, they paid for a new garden shed. The only thing I had to do was, you know, go out and replant some of my plants. That was the only out-of-pocket expense I had. And then a few years ago, a limb was blown off of one of my trees onto my neighbor's property. It only took out some forsythia bushes, which came back, and his insurance company came in, covered it, and you know, the macaroni was kind of cooked. I'm concerned where now it's going to be my responsibility to pay out of pocket because insurance doesn't cover. Having arborists come in and play with my trees, and the only way I can avoid any liability is to cut my trees down. So I think working on the details and working with insurers to decide which insurance company, mine or my neighbors, is going to cover any particular experience or is going to be important. This responsibility and liability has been came out of common law. It's hundreds of years old. Mostly tree limbs that are pushed, that are felled by weather. They come under the acts of God part of your property insurance, your homeowner's insurance. So I'm reluctant to replace that part of our insurance policy, which runs very smoothly and very well, and everybody comes away happy, and no one is forced to pay out of out-of-pocket expenses, my only out-of-pocket expenses was some plants. And replace it with a complicated system that requires arborists and bureaucracy and fights fights between insurance companies that I would have to get involved in. So explain to me why this is easier for a homeowner than the current system.
Thank you, Representative Godfrey. First, I'd like to state, I did not personally create the current bill that's in front of you. It was created by legislatures before me with groups of parties and individuals that thought this was a well thought out compromise and, passed out of this committee many times. So perhaps there's a way to tweak this and make this even better. But I think you will hear from Lisa St. Germain, who's my Newington constituent, is going to testify soon. As this process, although you described it as being, I forget your exact wording you just said, but convoluted, complicated. Why would this be easier than the current process? I think Lisa will tell you this would be much easier than the current process she goes through with her insurance company, dealing with her neighbors, tied up in lawsuits. And again, Representative Godfrey, we're only talking about trees that are diseased, decayed, and damaged that are likely to fall in the next 5 years. So as someone like you who has the trees located on your property, if that is the situation, then I think you should take some responsibility in needing to remove those trees or do some remediation of those trees, because it's going to fall within the next 5 years. It could cause damage to your own home, depending on the way it falls, or your neighbor. So there's some urgencies to it.
And even if it fell on my own home, my homeowner insurance would cover it 100%. That's my concern. Under the proposal, I'm going to have to start paying out-of-pocket expenses that I don't have to pay now. The only thing I have to pay now is every year I pay my homeowner insurance policy, several $1,000s, but lets me sleep at night. Now, all of a sudden, I'd have to be hiring an arborist who makes money by cutting down trees and coming in and saying, yeah, you have to cut down your trees and here's my bill. I'm a little wary of that simply because of my own experience. So that's my real. I don't want to take a relatively simple way of doing things that we have now and replacing it with a more complicated one and a more expensive one. So that's my concern. I think we share that, and I'm happy to work on tweaking the language to make sure this is true. And whether it's, what's a diseased tree? Norwegian maples are, for example, and it's the one that fell on my property from my neighbors. They're invasive species. They're junk trees. They get large and they hollow out, and they're more likely to be blown over than not. And the state of Connecticut is littered with them. And I use that word littered advisively because they proliferate and they're all over the place. So I think I share your concern to working out the details. Thank you.
Sure, Representative Godfrey, and like to work with you on that. And I'm not tied to or own this specific wording of every word in the bill. Sure, there could be a better way of doing it, but let's make it a fairer process for these homeowners that incur all of these $1,000s of damage. So let's try to figure out a better way for them. So thank you.
Thank you, Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Representative. Nice to see you again. A couple questions. I had heard earlier we were talking about this bill that Governor Malloy had vetoed it because there was no requirement of a licensed arborist, and that was this language corrected that. I don't see that correction. I see arborist, I don't see it prefaced by licensed. Could you direct me to where that, assuming that to be a valid concern, that is addressed?
Yeah, I don't know if it was a licensed arborist or just including arborist to begin with. I don't know if the chairman or anybody else has that recollection. It was before my time here in the legislature, but from my research and understanding, Governor Malloy had concerns based on the concerns given to him from some environmental groups that there was going to be healthy trees that were going to be cut down. Basically, a homeowner was going to say, well, I'm worried about a tree falling onto my neighbor's property and causing damage. I might as well just cut down the trees. And that was environmental advocates' concerns. So my understanding of this revised bill, having that arborist be somebody that goes and certifies that this tree is actually diseased, damaged, and needs to be taken down, would provide some protections for that homeowner who has the trees. Because if the arborist says, oh no, this tree is in perfectly healthy condition, and the tree falls anyway, the person is not liable. That's not their fault. Then it would be like the current situation where wherever the tree fell, that person is still causing liable for the recovery, a cleanup, damage, and things like that. So it's only when the arborist says this is a damaged, diseased tree. And I think that is the new additional language.
Okay, I thank you for that. And I noticed that there's no provision of protection for the arborist if the tree falls anyway. Arborist is being put in the position of, I guess, foretelling the future as to whether or not this is a diseased tree and more than likely to fall down. I guess if it falls down anyway, that arborist could be sued for, I guess, malpractice, something like that. I don't see any language addressing that.
Yeah, I'm not exactly sure if the arborist can be held accountable for that, but if so, perhaps there should be added language to protect them in that case.
Okay, I'm certainly in favor of clearing this up. The underlying intent of the bill. I recently had a 2-day hearing on a tree and whether or not it was diseased before the person chopped it down, and battle of experts on arborists. I learned a lot about arborists and what they do, and certainly have a better understanding of that. So I look forward to working together with you on something coming out of committee. So thank you, Mr. Chairman.
Thank you, Representative Fishbein.
Thank you. Further questions or comments? Seeing none. Thanks for being with us, Representative Turco. Next up will be Peter Mihalik. Mr. Mihalik. Is Mr. Mihalik with us?
Yes, can you hear me?
Yes, I can.
Oh,
yes, we can't see you, but we can hear you.
oh, okay. I'm on my iPhone. I apologize. I'm a little bit new at this Zoom thing. When I retired, we didn't have all these technology. So, can you hear me?
We didn't have it last year either, so we're all learning together. But go ahead, sir. You have 3 minutes.
Okay. Good afternoon. My name is Peter Mihalik, and I live at 11 Thomas Road, Westport. I'm appearing in support of House Bill 5598. This bill, as I understand it, will put responsibility of trees where it belongs, on the property owner for where the trees are. I have in the last years plus, been put in jeopardy, both physically and monetarily, by my neighbor's damaged trees. 3 of these trees are in imminent danger of falling on my property, my house, or God forbid, my grandchildren playing in my driveway. And just a side note, I have had an arborist look at these trees. They are in jeopardy of falling, It's just a question of time. These trees are very large, with one of them having very large branches hanging some 30 feet over my fence and my driveway. This particular tree has damaged my vinyl fence 2 times, and on one occasion that I'm aware of, dropped a large branch, missing my granddaughter by several feet. I immediately tried to contact my neighbor, who was an absentee landlord, to get no response, even a certified letter, numerous phone calls, and unanswered text messages. One day I saw him at his very rare visits to his property and showed him the damaged, rotted trees, and he agreed to have a tree company cut them down. He asked for 2 weeks until any leaves were on the trees, which there were not too many, to fall. This was October. He has done nothing, and I have made many attempts to contact with never a response. Since then, another limb has fallen and damaged my fence for the 3rd time. All this costing me money. And let me also say to that gentleman who thinks that this is a complicated bill, he claims that he paid nothing. Well, I would venture to say he either has a 0 deductible on his insurance, because I would think 99% of the people in this world do not. And they have at least a $500, maybe $1,000 or $2,000 deductible on their insurance. And dealing with any insurance company, and I am 70 years old, and I've had to do it many, many times, is never easy. They are out for themselves. As it stands now, this damage and cleanup costs would be my responsibility. How is that fair and reasonable? In any other situation, example, building a pool, the onus is on me to protect my neighbor's property from water runoff or soil runoff. Why isn't my unconcerned neighbor responsible to do me no harm? This bill needs to put the responsibility of trees back where it belongs, on the owners of the trees. In addition, this owner's property borders Thomas Road, a heavily traveled road by emergency service, police.
Sir, I just, we're over the 3-minute mark, so I just need you to summarize the rest of your testimony.
Okay. Basically, the owners of these trees, such as these, whether they are absentee or not, need to be held accountable for the damages they do. I want to thank Senator Haskell and your support for this bill.
Thank you, sir. Are there questions from the committee? Seeing none, I appreciate you being with us this afternoon.
Thank you.
Next up will be Lisa St. Germain.
Yes, can you hear me?
We can.
All right, thank you. Good afternoon. My name is Lisa St. Germain. I reside at 19 Cheney Lane in Newington, Connecticut. I would like to thank the Judiciary Committee for the opportunity to speak with you today in support of House Bill 5598, as well as the review of my written testimony submitted to the committee last week. My written testimony goes into more detail of what I'm going to speak to here, so I encourage you to review that if you have time. I would also like to thank Representative Gary Turco and his staff for listening to my concerns and inviting me to testify today. I have 3 properties that abut my property to the west, 1 to the east, and 1 to the south. I don't have a single tree in my backyard on my property. However, there are multiple overgrown trees that on all of the properties that surround my lot. Over the course of the past 14 years I've resided here, I've had close to $5,000 worth of tree damage, cleanup, and maintenance due to my neighbor's trees. The most recent was just yesterday, as due to the windstorm that happened throughout the state, a large part of my neighbor's pine tree came crashing down into my yard, and I had to pay someone yesterday to come and cut it up, and I will have to remove the remnants later this spring. My neighbor has admitted that they are too tall. They're sugar pines, at this point structurally damaged due to previous breakage, but refuses to do anything about it. And why is that? It's because as these trees get damaged and they fall into my property, he has no responsibility to pay for the cleanup or for the damage the way the current law is written. During another storm, we had a neighbor 60-foot pine tree come down into our backyard, and their response was, "Not my problem. You're responsible for the costs," and they proceeded to walk away. And $2,000 later, and again, I applaud the previous gentleman, we do have deductibles on our homeowners insurance. The tree was removed and the indents in the lawn were repaired, and all of that was out of my pocket. Why? Because I didn't want my homeowners insurance to go up for several years later because I made one claim because of a neighbor's tree falling in my yard. The current law puts all the responsibility on the victim of such damage and none on the homeowner whose property contains the tree. Yes, homeowners insurance can kick in, maybe, but then rates go up, again, for the victim of the damage, not the homeowner who owned the tree and should have had all the responsibility to maintain the tree. It's important that we hold property owners responsible for the maintenance of the trees, and if the property does incur damage due to their tree falling, they are held responsible for the cost of the repair and the cleanup of such damage. As I said earlier, I want to thank the committee for hearing my concerns and emphatically encourage you to support House Bill 5598 to put the responsibility and the cost of the maintenance of a homeowner's property and any damage caused on the homeowner of that property and not on the victim of that damage. Thank you.
Thank you very much. Are there comments or questions from members of the committee? I do not see any. Thank you very much for joining us today and offering your testimony.
Thank you. I appreciate it.
Next, we will hear from Susan Williams. Is Susan Williams here? And if Susan Williams here, we'll hear after that from Dave Falvey and Christopher Kelly. Is Susan Williams here? Okay. Is Dave Falvey here?
Yes, sir. Can you hear me?
I'm here, actually, Susan Williams.
Oh, we have Susan Williams. So we'll hear from Susan Williams and then Dave Falvey.
Okay.
You may begin.
All right.
Thank you. Can I begin?
Yes, you may.
Okay. Thank you for allowing me the opportunity to speak today. I'm actually going to change it up, and I'm going to be speaking in support of House Bill 6466, which is the amendment to the exemptions. And in particular, I would like to address the increase in the homestead exemption. I am a bankruptcy attorney living and practicing in the state of Connecticut for the past 31 years. And in 1993, 3 years after I started practicing law, Connecticut increased its homestead exemption to $75,000. And that was 28 years ago. The homestead exemption has not been increased since that time, with the exception of the 2003 increase to $125,000, but that's specifically for debts related to medical services. And I have to say that I have filed thousands of bankruptcies over the years. And because this is such a narrow exception, I have never had the opportunity to utilize that narrow $125,000 exemption. Connecticut has one of the highest median incomes in the country. And being in the Northeast, we all know how valuable homes are and how expensive it is to purchase real estate. Valuations of homes have increased tremendously since 1993, and the homestead should be updated to reflect that increase as well. Our bordering states, Massachusetts and Rhode Island, have both increased their homestead exemptions to $500,000, and the legislation before you affects hardworking homeowners that have been loyal to the state of Connecticut, continuing to live here, contribute to the Connecticut's economy, paying real estate taxes, acquiring equity in their homes, and sometimes actually paying off the mortgage. So this homestead exemption applies to judgment lien creditors. We're not talking about consensual mortgages. It's always a difficult time when someone decides to file for bankruptcy. Typically, people fall on hard times, which are typically unavoidable, unforeseen circumstances such as divorce, illness, job loss, and now pandemics. If a homeowner has more than $75,000 of equity in their home, then Connecticut is denying these hardworking residents the opportunity of a fresh start because there's too much equity in their home. Connecticut is saying you work too hard and stayed in Connecticut too long because the state of Connecticut will not protect that equity that you work so long and hard to achieve. My office is situated on the Massachusetts line, and I practice both Connecticut and Massachusetts. I'd like to give you an example of a case in point that just recently came to my office. A woman, an elderly woman, Joanne, came to me because her husband had passed away. Joanne and her husband, Tom, had lived in Connecticut their entire lives and purchased a home in Suffield and had paid it off. Joanne and Tom were getting by on their Social Security and also a part-time job held by Tom. And they did have existing credit cards in their names and they were current on all of them. And then Tom passed away. Joanne's income was cut in half. And because the mortgage was on the home was paid off and Joanne was the only one on the title to the house, she could not qualify to file for bankruptcy to get her fresh start. I advised Joanne that I was sorry she lived 1 mile south of the Massachusetts line, because if she wasn't living in Connecticut and was living in Massachusetts, we would have been able to protect her homestead because Massachusetts allows $500,000.
I would just advise you that your 3 minutes have elapsed. If you could summarize, thank you.
Almost 3 decades is much too long to wait to amend the home bankruptcy exemptions. I'm in support of the bill to raise the homestead exemption to $250,000. And I would hope it would be clear that the exemption will be in keeping with the old legislation and be per person. So married couples holding title jointly will be allowed the full $500,000 exemption.
Thank you very much. Representative Fishbone.
Thank you, Mr. Chairman. Good afternoon, ma'am. Thank you for coming and testifying here today. Understanding the bill's only 7 pages long, I would I guess assume that you've had a chance to review the entirety of the bill, and I just wanted to ask you if you had any objection to any of the changes.
I believe the bill itself, I was talking very quickly, so I was trying to get in really supporting the homestead exemption because we desperately need that. But the automobile exemption, yes, there were only 3 changes that I saw to the exemptions. I believe more of the exemptions can be revamped, but we'll take what we can get. The increase in the automobile exemption from $3,500 to $7,000 is long overdue. I am in support of that, as well as the exemption for individuals to exempt out cash value and life insurance policies. I believe that was the 3rd one as well.
Okay, so I asked if you were opposed to any portion of this bill.
I am not opposed to any portion of the bill, no.
Okay, so I have to ask, at lines 58 through 62, you've given us a lot of good reasons why we should be raising this exemption. And just so that, you know, we can frame what this is, these are state exemptions when a bankruptcy is filed. The petitioner is allowed to keep certain assets, even though they're filing for bankruptcy. And this is the schedule of things that are exempted from them having to forfeit or give up in the bankruptcy procedure. Is that fair to say?
That's correct.
Okay. So in lines 58 through 62, you say, well, I'm in favor of raising the exemption from $75,000 to $250,000, except in certain cases. So why are you in support of those exceptions? And I'm just going to read, you know, what that exception is. Any claim of sexual abuse or exploitation of a minor, sexual assault, or other willful, wanton, or reckless misconduct committed by a natural person to the value of $75,000. So you would have it kept the same in those particular instances. Why are you in support of that carve out?
Well, I believe that the discharge that an individual receives in bankruptcy is very powerful. The bankruptcy code, and we're speaking about state exemptions. When an individual files for bankruptcy, you also have the option of utilizing federal exemptions. Our state allows both, but you have to choose one and be consistent. And there's also within the bankruptcy code, the federal code that bankruptcy is governed by, there are certain obligations that you are not able to discharge, such as if you have willful, wanton, or reckless behavior. So I think it's in keeping with the code and things that would be non-dischargeable if you were to file a bankruptcy. And also, I believe that debtors don't have much of a voice in any legislation that you're willing to give people, the hardworking people. If you can protect, equity in their home and you raise that above 75,000, if you have an exception for people that are sexual abusers or there's willful or wanton judgments, I think I would not have a problem with leaving that in.
So I recently lost a friend who was hit head on by a drunk driver. That's negligence. That's not willful. You would have that under this language, that drunk driver would be able to protect more assets or less assets under this language.
If it's negligence, it's not willful and wanton.
That's right.
So, yeah. So.
So that individual would get more of a protection, correct?
Correct.
So I'm just trying to understand why the carve out. I understand the premise for the bill. The carve out is a little troubling for me, because of how it's structured. I understand that some may be in support of that limited. But from my perspective, if you're going to do a carve out, then why make the change at all? Right? It should be, and especially the drunk driving situation, but anyway, I thank you, Mr. Chairman. Thank you.
Thank you, Representative Fishbein. Senator Kissel.
Hi. Thank you, Mr. Chairman. You said that you're up near the Massachusetts border. I represent 7 towns in north central Connecticut up near the Massachusetts border. I'm just wondering where you're coming from.
I lived in Suffield for 33 years and my practice is in Enfield, Connecticut. I've had my practice here for 21 years. Prior to that, I was with a firm in Farmington.
Wow. So you're my constituent.
Yes, I've been here a long time.
Yeah, awesome. We haven't bumped into each other.
Yes. And, I have to say, the debtor's practice, I'm a solo practitioner and, I understand how busy we all are and our debtor's voice need to be heard on this legislation. We don't have a lot of backing. We don't have a lot of financial support. Most of the creditors do. And I really felt the need to be heard on the increase in the homestead exemption.
Well, ma'am, I just want to let you know that I always support my constituents. So I support you on this bill as well. And it's great to see you. Thank you for coming and testifying.
Thank you, Senator Twissell. I appreciate that.
Thank you. I do not see anyone else. That being the case, thank you very much for joining us and offering your testimony today.
Thank you.
We'll hear next from Dave Falvey, and he will be followed by Christopher Kelly. Mr. Falvey, you have your 3 minutes.
Thank you. Can you hear me? Can you hear me?
Hear you quite well.
Good, great, thank you. Hi, thank you for letting me come forward and support House Bill 6466, the homestead exemption, and also the motor vehicle exemption. I'm a bankruptcy attorney in Groton, Connecticut. I've been in practice 38 years. I'm near the Rhode Island border. And one of the points, this was brought out by Attorney Williams, Massachusetts has a $500,000 homestead exemption. Rhode Island has a $500,000 homestead exemption. And of course, New York, depending on the county you live in, has a $300,000 exemption. And other states like Florida have an unlimited exemption. This is very important in retaining people in Connecticut because there's always the discussion in bankruptcy about where to file. And I've had situations with clients who, if they lived in Rhode Island, would have been able to file bankruptcy. Now, historically, Florida and other states, in order to attract people to their state, changed their exemptions drastically. Florida, it could be unlimited exemption. Now, a recent case in point was the Subway shop, which was originated in Connecticut. And they moved to Florida because of estate planning exemptions. Well, bankruptcy planning regarding finances and estate planning regarding finances come down to laws that either hurt or help people. Florida, in order to attract people, made their laws more attractive and helpful. Well, where many people are leaving Connecticut, and I've had discussions with people of moving to Florida and moving to Rhode Island. And we're losing people in Connecticut. We're in a neighborhood where everyone around us has a $300,000 to a $500,000 exemption. Connecticut never had an exemption till about a homestead exemption till 1991. And they haven't changed it at all. The federal exemption moves up in with the economy. It's geared to that. Well, we've never really changed that exemption since approximately 1991. I'm not positive that's the exact year we first got a homestead exemption, but I'm pretty close if I'm not totally correct. And I see that the hardship that this works on people when they fall on hard times, that the property values, for instance, in the London County, the average
Mr. Falvey?
house is 240.
Mr. Falvey, Mr. Falvey, I'd like to advise you that your time is expired. If you could summarize.
Thank you. Well, it's long overdue that this exemption be increased. And regarding the cars, of course, there's no question right now, I think our car exemption is $3,000. And that's just about a junker car, and it might not operate. It's getting to that point. So I feel that we've been very stingy with our exemptions, and it's really hurting people. And actually, it's causing, I feel, people to move out of state.
Thank you, Mr. Thank you, Mr. Falvey. Are there comments or questions from members of the committee? I do not see any, so Mr. Falvey, I would like to thank you for joining us today to offer your testimony. I hope you have a great day.
Thank you very much.
Christopher Williams, followed by, in my handwriting, I wrote it down, so it looks like William D. I'm not gonna say it yet, I'll figure it out. Chris, is Christopher Kelly here? I think I saw the name.
Yes, I am.
And I think it was D. Cristofaro, but my handwriting is terrible. That's correct. You may begin, Mr. Kelly.
Thank you. Thank you, co-chairs Winfield and Staffstrom, vice chairs Castor and Blumenthal, ranking members Kissel and Fishbein, and members of the Judiciary Committee for this opportunity to testify today. My name is Christopher Kelly, and I'm the Peter B. Cooper Legal Fellow at Save the Sound. I'm testifying today against Senate Bill 938, an act concerning land use appeals. Senate Bill 938 amends General Statute Section 8-8, subsection N, which deals with appeals from the decisions of land use bodies, such as planning and zoning commissions and zoning boards of appeal. This subsection only permits the settlement of or the withdrawal of an appeal after a hearing has been held in Superior Court. On its face, Senate Bill 938 may appear to improve efficiency by permitting withdrawal prior to that necessary hearing, only requiring the hearing if the defendant, which would be the commission, objects to withdrawal. That would obviously not happen if the withdrawal is due to a settlement. However, rather than facilitating efficiency, this bill undermines accountability by insulating land use decisions from the input of the public. Land use matters are public matters, cannot be resolved solely between two parties. That's exactly why the initial land use matters from which these appeals are born are matters of public record, open to testimony, and requiring that decision makers justify their actions. Likewise, the purpose of the existing statute is to ensure that zoning matters can be scrutinized by the public by means of a public record. If this bill were to pass, appellants would have the opportunity to obtain settlements potentially aided by the threat of litigation against the municipality, without giving the court the opportunity to hear from other parties and without establishing a clear public record of how the settlement can be justified. The court is responsible for ensuring that these appeals are disposed of fairly and responsibly. It has the power to approve or deny the withdrawal of an appeal and the enactment of a settlement. But by removing the opportunity to hold a hearing, the court's own power is diminished by limiting its ability to solicit necessary information and context. This includes information from other parties who may have pertinent information on the matter, and perhaps more importantly, from other parties whose interests may be different from the appellant and the commission. It is still affected by the outcome of the case. Save the Sound is a nonprofit environmental organization which uses legal and scientific means to protect the land, air, and water of Connecticut and Long Island Sound region. We are speaking in opposition to this bill, along with practitioners and environmental organizations who have submitted written testimony, because we are uniquely familiar with the benefits of casting sunlight upon land use proceedings. We have often relied upon the Connecticut Environmental Policy Act to protect the resources of our state, at times from unwise land development plans, because it contains an intervenor provision allowing anyone to become a party to a proceeding if they can establish the unreasonable environmental threat presented by the case. The current hearing requirement is necessary for us to participate in the final disposition of a land use decision. Were this bill to pass, our organization's ability to protect Connecticut's natural resources would be severely impaired. The rights of all members of the public who may find their interests jeopardized by a land use decision would be severely impaired. Efficiency cannot justify undermining accountability. Thank you for this opportunity to speak out against this bill.
Thank you very much, Mr. Kelly. Are there comments or questions from members of the committee? I do not see any, so I would like to thank you for joining us and offering your testimony today.
Thank you.
William D. Cristofaro, followed by Joy Avalon.
Thank you, Senator Winfield, Chairman Winfield, and other members of the Judiciary Committee. I appreciate the opportunity to speak with you today. My name is William D. Cristofaro. I'm a licensed insurance producer. I'm representing the National Association of Insurance and Financial Advisors. I'm also a veteran producer with nearly 40 years experience. I'm asking for support for HB 6466 concerning property that is exempt from a judgment creditor, specifically as it applies to life insurance cash values. I wish to make it clear that I am not representing insurance companies. They, in fact, benefit by the current statutes. Rather, I am speaking on behalf of beneficiaries, those widows and orphans. Let me explain. For a simple comparison, there are two types of life insurance, term and permanent insurance. Term has an expiry date. It bills no cash value and is rarely paid. It is very profitable for insurance companies and is not affected by the changes in this bill. Permanent insurance is designed to be paid regardless of how long you live. In order to make this commitment, insurers set aside premiums in excess of the monthly expenses. And this extra charge is set aside like a sinking fund, and it offsets the increasing mortality expenses. While it's available for a loan or surrender, it is integral to maintaining coverage. Without it, the policies will lapse. Here's a real life example. This week, I'm filing a claim for one of my former clients. She had a $750,000 universal life policy. She and I worked together for 30 years and she paid it every single year. So her cumulative premium was just over $75,000. And the surrender value before she died was $122,000. Currently, all but a small portion of that $122,000 would be subject to creditors. I believe the amount right now is $4,000. I'm really not certain how that number was derived, but if we took any money from that cash value before she died, the policy would have lapsed. This would have meant that her beneficiaries would have received nothing, and the insurance company would have got to keep the difference between the $750 and the $122. I'm certainly in agreement with the trial attorneys pointing out that involved injured parties are due recompensation. However, if a policy no longer exists, it's really the innocent beneficiaries who ultimately pay, and the life insurance and the life insurance and life insurers that ultimately benefit. We want to protect and exempt these benefits, and yet without the cash values, the benefits cannot be paid. Thank you, and I invite any questions you might have.
Thank you, Mr. De Cristofaro. Are there comments or questions from the committee? Representative Blumenthal.
Thank you, Mr. Chairman. Just a quick question. You noted the exception to the exemption for certain forms of reckless misconduct or claims arising from certain misconduct or sexual assault. And you spoke mostly on the life insurance policy issue. Would you be amenable to a similar exception to the exemption for the life insurance benefits exemption?
I suppose, however, I do want to reiterate that I believe it's the beneficiaries. So those beneficiaries are innocent. And so in spite of the fact, if they're not getting claim at all, then they're actually losing out on a potential benefit that they had no involvement in causing harm. And furthermore, those beneficiaries without that insurance might ultimately become wards of the state in some form or another. So I'd be open for negotiation because anything would be better, but I'd like you to consider it from the perspective of the beneficiary, those widows and orphans.
And I appreciate that perspective and the idea of an innocent beneficiary. What if the beneficiary were a wrongdoer?
Well, at this present time, I don't understand that beneficiaries, I imagine right now, beneficiaries are subject to claims if they were the one, subject to creditors if they committed some sort of heinous act. So that would be fine.
Okay.
I'm not talking about the benefits being protected. I'm talking about the cash values being protected.
Okay. Thank you, sir. I appreciate it. And thank you, Mr. Chair.
Thank you, Representative. I do not see anyone else. So thank you for joining us today to offer your testimony.
Thank you, Senator.
Thank you. We'll hear next from Joy Avalon, followed by Kelly Petter. Joy Avalon.
Hi.
You have your 3 minutes.
Great, thank you. Senator Winfield, Representative Staffstrom, ranking members and distinguished members of the Judiciary Committee. I'm Joy Avalon, General Counsel for the Insurance Association of Connecticut. I want to thank you for the opportunity to offer our strong support today for House Bill 6465, which seeks to prevent windfall recoveries for plaintiffs that are based on what's known as phantom damages. This bill really doesn't concern the legitimacy of medical billing or cost of treatment. I have trouble understanding how it will impact or affect predictability or how it will make reaching settlement any more difficult than it already is. All due respect, I believe that these issues are somewhat more red herring. This bill will help keep defense costs reasonable, facilitate settlements, ensure that settlement values and awards are reasonable and fair, and that they appropriately compensate injured parties for the actual damages that they suffered. In doing so, it will help to keep insurance premiums affordable for consumers as well. The purpose of personal injury is personal injury law is to fairly compensate a person for financial losses as well as emotional and physical losses that they suffered. The amount that an injured person recovers via settlement or award after a trial is based on two types of damages, economic and non-economic. Economic awards are based on quantifiable losses, financial losses, and as such, evidence of medical bills and lost wages are submitted at a trial. And non-economic damages are really all other kinds of damages, such as pain, suffering, and emotional distress. This bill will only impact awards of economic damages. It aims to have economic damages calculated based on actual financial damages in cases where a right of subrogation exists, just as is done currently in cases where no right of subrogation exists. We're not proposing that tort reform be revisited or revised. As I understand it, this bill supports the practice that was really in place prior to a 2016 Connecticut Supreme Court decision, Marciano versus Jimenez, which strictly construed the relevant statute and changed how things were done. That decision is controversial because it allows awards to be made based on medical bills and expenses that neither the plaintiff nor anyone else is responsible to pay. And as such, these damages are called phantom damages. And when these damages are used to inflate the amount of the settlement or award, they result in a windfall recovery to the plaintiffs. So how does this play out? Well, a plaintiff in a personal injury case sees a healthcare provider for injuries they sustained. Providers have different fee agreements with different payers for the same procedure. So these are negotiated rates. So rates paid by Medicaid, Medicare, workers' comp, and PPOs are gonna vary, pretty significantly. But essentially, these payers are all paying a small percentage of what the actual billed amount is, and the provider accepts that amount in full satisfaction per their contract or their agreement. Now, insurance may pay $30,000 to a medical care provider in full satisfaction of $100,000 of billed medical services per the terms of their agreement. And then that balance, that $70,000, becomes a write-off for the medical care provider. Now, no one, including the injured party, has a financial obligation to pay that amount. It's not a loss, it's a phantom damage. So using an example where someone was on Medicaid in a personal injury case, because Medicaid has a right of subrogation, evidence of the $100,000 in medical bills is presented during the trial, factored into the award of economic damages. And even though the $30,000 was paid to Medicaid and no one has an obligation to pay the 70%, that was written off. Now, prior to
I would like to advise you that your time has expired. If you could summarize.
Yep, I'll wrap up. So in summary, prior to Marciano, that $70,000 would have been reduced from the economic award after the trial, so the plaintiff wasn't compensated beyond what was fair. Marciano has really now caused the plaintiff to pocket that $70,000, even though no bills or liens are outstanding. So this bill really seeks to ensure that plaintiffs are made whole through fair compensation, which also serves to keep insurance premiums affordable. And I'm happy to answer any questions you may have.
Thank you very much. Let me check. Are there comments or questions from members of the committee? Comments or questions? Representative Blumenthal.
Thank you, Mr. Chair, and nice to see you, Ms. Avalone. I appreciate your testimony and your position. Obviously, you could probably tell that I don't agree with it. There's one thing I found troubling in the testimony from folks who are supporting this bill and have in the past, and that is the characterization of Marciano. You didn't really do this in your written testimony, but a number of the testimonies that were submitted in written form and in past years that have been made orally have characterized Marciano as some sort of huge departure from the law or otherwise a completely unexpected result rather than a decision based on the plain language of the statute that was passed. So I guess I would just say that I find that troubling, and I would appreciate in the future if the decision were not characterized that way. I appreciate you have a policy view on the matter, and that's absolutely fine. But a number of people, I guess you can't control everyone who supports the bill, but I guess I'm just saying that I found that troubling, and I hope that it will not keep occurring.
Are you suggesting that I mischaracterized it? I'm sorry, I'm not sure that I follow.
No, I haven't seen your written testimony and in your oral testimony. I think you indicated that you didn't like the result, but that it was based on the statute. There have been folks in the past who have not characterized it that way.
Oh, okay. Well, yeah, I mean, just to clarify, it is my understanding in speaking with other practitioners, trial bar and defense bar, that the practice did change after the decision in Marciano. I apologize for the dogs in the background, but the practice did change after Marciano. And I think that's why we've seen bills, proposed in response to that decision. So I hope I didn't mischaracterize it, but yeah, that is our position right now.
Thank you, Mr. Chair.
Thank you, Representative. Representative O'Day.
Thank you very much, Mr. Chair. And thank you very much, Ms. Avalone, for your testimony. When you say things changed, how would you describe how they changed since Marciano?
Well, it's my understanding that the practice prior to Marciano was, basically that what this bill seeks to accomplish, that was the practice before Marciano. And because of a strict interpretation of the statute 52-225A, that that we're in the state that we are now. So we're seeing, as a result of that, where collateral source reductions are not allowed, we're seeing the settlement values of cases are inflated, and also awards by juries are inflated as well. And do you has your industry done any studies on that, the inflation of the verdicts and settlements at all that you could provide, or? Yeah, so I actually I've been trying to obtain that information. It has only been a few years, so I'm doing my best to collect it. I don't know of any studies to date. This is information that's been provided to me from people who are practicing in this area, and so that's what I'm relaying to you. But as soon as I get data to support that, I will actually absolutely pass it on.
Thank you very much for your testimony. Thank you, Mr. Chairman.
Thank you, Representative. Are there other comments or questions from members of the committee? Seeing none, Ms. Avalon, thank you very much for joining us today and offering your testimony.
Thank you very much.
We'll hear next from Kelly Petter, followed by Erica Amarante.
Good afternoon. Can you hear me okay?
Hear you quite well.
Great, thank you. Good afternoon, Chairman Winfield and Staffstrom, ranking members Kissel and Fishbein, and other distinguished members of the committee. I'm here speaking on behalf of the Connecticut Defense Lawyers Association, and we support House Bill number 6465 because it's in the best interest of all of your constituents, and it serves the purpose of Connecticut damages law in personal injury and wrongful death cases. The reality is that this bill is not a question about whether the defendant or the plaintiff should receive a windfall. In fact, the question is, should an individual litigant be allowed to receive economic damages for an amount that she has not paid and is not expected to pay in the future, but will increase settlement values in the state, verdict values in the state, thereby increasing insurance premiums? That's the issue we're dealing with here, and it's affecting every single person in the state of Connecticut that has to purchase any type of liability insurance that would cover bodily injury. In reality, in practice, Marciano changed what was done in the courts. I would agree with Representative Blumenthal that the court in Marciano did not change the language of the statute, nor did it, in fact, interpret what was intended by the legislature in passing the statute. What the court did was it said that they were required to only look at the words in the statute and apply what they believe those words mean as they interpret them today. And that is not looking at what was intended when it was passed. In reality, before Marciano, all of the attorneys, plaintiff and defendant alike, and judges throughout the courts accounted for a collateral source reduction of the difference between the total amount of medical bills and the amount of any right of subrogation. After Marciano, that's no longer true, and plaintiffs' attorneys are routinely using the Marciano decision as a basis to increase settlement values and increase verdict values of damages claims that would have had a different value before Marciano. We're also seeing inconsistent results. One plaintiff who may be a constituent in your area would receive a completely different result than another plaintiff who's also a constituent in your area with the same exact damages claims. This is also inconsistent with damages law. In support of our testimony, I've submitted what the standard civil jury instructions state. And when they talk about economic damages, they talk about amounts incurred or likely to be incurred in the future. In fact, the amounts that are allowed to be recovered as a result of the Marciano decision are not amounts that were incurred by the plaintiff, nor are they amounts that are likely to be incurred in the future. You were told earlier that a jury is allowed to decide what's reasonable and necessary medical expenses, but in fact, that's not true. Recently, this legislature changed a statute at the request of the Connecticut Trial Lawyers Association, which made it so that the plaintiff's lawyers are allowed to submit the total amount of the medical bills claimed. And in a collateral source hearing after the fact, the court was to consider write-offs.
Ms. Petter, if you could summarize, your time has expired.
Yes, thank you. We believe that this statute would help all of your constituents across the state. We believe it's consistent with the law, and we also believe that it's consistent with the purpose that was intended by the statute when it was written, and we urge you to support it.
Thank you very much. Are there comments or questions from members of the committee? I do not see any. Just one question for you. You said you had submitted this testimony, correct?
That's correct.
Thank you very much. Seeing no questions, thank you very much for joining us to offer your testimony today. Have a great day. We'll next hear from Erica Amarante, followed by Sophia, it looks like Demansky.
Good afternoon. Can you hear me okay?
I hear you.
Great. Good afternoon, Senator Winfield, Representative Staffstrom, and distinguished members of this Judiciary Committee. My name is Erica Amarante. I'm a partner at Wiggin and Dana and president of the Connecticut Defense Lawyers Association. I thank you for allowing me to testify today on behalf of the CDLA to express our strong support for raised bill number 6465. I will refer to the written testimony that we have provided, and I will not belabor the points that my colleague Kelly Petter has already made as she testified right before me. But there's a couple things that are undisputed. It's undisputed that the collateral source statutes, when they were originally passed in the 1980s, they were aimed at fairness and at preventing double recoveries and windfall judgments, furthering the goal of providing injured parties with fair, just, and reasonable damages. That was the purpose. And I do agree with prior speakers who have said that there was an intricate balance and a give and take when those statutes were passed. I will tell you that part of that intricate balance was 52-225C, which is part of the collateral source statutes that were passed, and that is known as the anti-subrogation statute. So what it said was that in that statute, insurance companies in this state are actually prohibited from exercising a right of subrogation and requiring injured parties to pay that money back. And that makes sense because the statute also said that there wouldn't be a deduction when there is a right of subrogation. But what's happened over the last 30 years is that there have been many decisions that have said that federal law preempts that state law. And so when you have a federally funded insurance plan like Medicare or an ERISA health plan, that they do exercise a federal right to subrogation, and the anti-subrogation statute, which was integral to this collateral source regime, is effectively nullified. So now we have a situation where things have changed, and it is more common than not these days for a patient's medical bills to be paid by an insurance plan that does have a right of subrogation. So this exception to the collateral source statutes has now swallowed the rule. Just using Medicare as an example, the gap between what's billed and what's paid is significant and growing. And in 2012, as Attorney Petter referenced, Public Act 12-142 addressed the issue of write-offs from a bill and how that should be addressed. And what this legislature did was that they said the entire bill can go before the jury with the comfort that we know the trial judge on the back end will have a collateral source hearing and will deduct and will reduct what was written off and a factor in what was paid and what the premiums for that insurance were. And the problem is now is it's undisputed that if a bill was paid by an insurance company without the right of subrogation, that would happen. The trial court would have a hearing after any verdict and ensure that the economic award reflects the reality of what was paid, what it cost the plaintiff to receive that insurance, and provides her only with the amount of damages that reflects what was actually incurred. But that doesn't happen when there's a right of subrogation under the Marciano decision. This leads to a situation where you have similarly situated plaintiffs receiving different damages awards.
Ms. Amarante, your time has elapsed. If you could summarize, thank you very much.
Yes, definitely. I do want to point out that this does not implicate all of tort reform because there have been tweaks to the collateral source regime before, as I mentioned, in 2012. And I do think that we should have a consistent system with a collateral source hearing occurring at the end of any verdict after any trial so that judges can do this justice and judges know how to do it. And I thank you for your time and your consideration of this important bill.
Thank you. Representative O'Day.
Thank you, Mr. Chairman. And thank you, Attorney Amarante, for your testimony. Just if you could clarify for the members of the committee who may not be trial attorneys and for public watching, when you say that two plaintiffs in this identical case could have different recoveries based on whether or not there's a reimbursement or not. Could you just give that example?
Yes, I will. Thank you, Representative O'Day. And I laid this out in my written testimony as well. But if you assume for a minute two plaintiffs, A and B, both are in a motor vehicle accident, the medical bills for both are $100,000, for instance. The jury will see those bills only. And so the jury will award economic damages of $100,000. Plaintiff A has an insurance company, has an insurance coverage that does not have a right of subrogation. So they have a collateral source hearing at the back end, and the judge will look at what was actually paid and what the premiums were that plaintiff A paid to receive those insurance benefits, and will make a substantial deduction. And so in my hypothetical, I said that the premiums were $5,000, just to use rough numbers and make it easy. That plaintiff A, whose insurance plan does not have a right of subrogation, is going to have the economic damage portion of her award reduced by $95,000. So she's going to get only the $5,000 that she actually incurred for her insurance benefits, and she is not going to receive the billed amount that was not paid on her behalf. And leaving aside, I will mention that this does not address the non-economic portion. So the non-economic damages are not addressed here. This is just the economic piece and what was actually occurred. Now, if you assume the same thing for a plaintiff B, whose insurance company is an ERISA plan and has the right of subrogation, that ERISA plan now, she does not get the collateral source hearing. Plaintiff B does not. And so she walks away with $100,000 in economic damages, even though that was fully paid for by her insurance policy, and the premiums, for instance, were also $5,000. So plaintiff B is in a very different situation than plaintiff A. And oftentimes what we do see is that even when there's a right of subrogation, it is not exercised in some cases at all, or even if it is exercised, it's not fully exercised. So if an insurance company, for instance, did pay that $100,000 medical bill, they would have negotiated a different rate. So they would have paid $40,000. And the plaintiff now, having a right of subrogation in that plan, receives a windfall of $100,000 in economic damages. And the purpose of our damages law is to make a plaintiff whole, to give them what they actually incurred back and make it fair, just, and reasonable. And under the Marciano decision, treating plaintiff A and plaintiff B so drastically differently does not make sense. And so the trial court should be free, and the judges have hearings and look at medical bills all the time. They should be free to have a collateral source hearing in both instances and let the judges decide. And that's what the judges were doing before, as we see from the trial court decision in Marciano. Judge Swighton did that, and she did have a collateral source hearing, and she made the reduction until the Supreme Court told her she shouldn't have. And we see it happening now after Marciano, where judges, recognizing that this is unjust, are using the law of remittitor, which is a different mechanism, to do the same thing. And I cited in my written testimony a decision by Judge Andrew Rohraback that did that as well. So this is really just to make the two plaintiffs have the same outcome. Thank you very much, Representative O'Day.
Thank you, Mr. Chairman, and thank you, Attorney Amirante, for your testimony.
Thank you, Representative. Are there comments or questions from other members of the committee? I do not see any. I'd like to thank you very much for joining us and offering your testimony today. We will hear next from Sophia Domansky.
Good afternoon, co-chairs and ranking members. Thank you for raising bill number HB 6466. I'm here to speak in support of it. My name is Sophia Domansky, and I'm a financial advisor for almost 14 years here in Windsor, Connecticut. I'm also a current president of NAIFA Connecticut, or the local chapter of the National Association of Insurance and Financial Advisors. There are a couple of reasons of why we're in support of this bill. First of all of the Connecticut's surrounding neighbors protect 100% of the cash value of whole life policies from creditors. MA exempts all cash values from their claims of owner creditors. New York protects 100%. And in Rhode Island, non-owner beneficiaries of the policy owners are also protected from the insured creditors. Connecticut only protects $4,000 of the cash value. So we're not in line with our neighboring states. Well, why is it important to protect the cash value? Well, just like Mr. De Cristofaro stated, if a creditor were to pursue the cash value of the life insurance policy, it could potentially collapse the policy, which is needed for the protection for the spouse or family members. Well, what if the insured is no longer insurable? They will never be able to protect their family ever again. The life insurance policy or the cash value of the policy can also be used as a buffer asset for the retirement planning as well, where those funds will be needed in conjunctions with other assets like a 401k or a form of an IRA. The cash value in a life insurance policy should be protected just like the assets of the 401k or an IRA are today for essentially the same principle. The issue is important because with the advent boom of the baby boomers generation retiring, there are more people needing these protections as they leave the workforce and may need to access those funds. We appreciate your consideration for this very important legislation.
Thank you very much. Are there comments or questions from members of the committee? Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon. I don't know if you were here when I asked questions from somebody else who testified in favor of this, but in lines 58 through 62, exempt certain judgments from this raising of the exemption. Are you in favor of that?
Absolutely. We are in support of having unlimited cash value protection.
Okay, when you
And
say,
we're here specifically, I'm here specifically for the cash value protection of a life insurance policy.
okay, so you're here testifying in support of lines 48 through 52 or the entirety of the bill?
I support the entirety of the bill, but we're here testifying for the cash value part of the life insurance.
Okay, so I want to bring you back to the 58 through 62 lines that say that the exemption is going to be raised to $250,000. That people have judgments up to that amount. Their house can't go after, the bankruptcy court can't do anything with. But then there's that provision at the bottom that says, for certain cases, we're going to keep it at 75,000. So that would run contrary to the spirit. Are you in favor of lines 58 through 62 or?
Yeah, I'm gonna apologize. I did not read the bill. We're here specifically for the cash value protection of the life insurance policy.
Okay, well, that's why I had asked you the question.
Yeah, I apologize. Yeah.
Okay, so you haven't read the bill.
I did not. It's the cash value part of that.
Okay, so it'd be unfair to ask you about the entirety of the bill. So thank you, and thank you, Mr. Chairman.
Thank you, Representative Fishbein. Representative Blumenthal.
Thank you, Mr. Chair, and thank you for being with us here today, Ms. Mansky. I'm going to ask you just the same question, basically, that I asked the other witness testifying for the cash value life insurance part of the bill. Would you be opposed to applying the exemption that exists for the exception to the exemption for the value of the home? So that's essentially accepting from the exemption people who have a judgment against them for, sexual assault, serious forms of misconduct, including willful, wanton, or reckless behavior. Would you have any opposition to applying that exception to the exemption that you're here testifying about today?
So let me see if I understand you clearly. So let's say a father who bought a life insurance policy when he was 30 years old, when he's 50, does a reckless driving, and now his child cannot get the life insurance proceeds that were put in place, and then the child is really who is suffering from the father's mistake.
I take it that's your position.
Yeah, yeah. I don't think kids should be penalized for their parents' mistakes.
Okay. I mean, and I'll put it this way. Do you think that the person seeking compensation, do you think the fact that they're being compensated for that kind of very serious, or they're seeking compensation for that very serious kind of wrong, do you think that should be weighed against whether the beneficiary should get the policy? Do you think those two things should be weighed at all, or do you think it just the beneficiary should get the value of the policy?
Just like the surrounding states, I am in full support of having the death benefit proceeds of the insured be fully protected from creditors.
All right.
Because
Thank you,
once
Mr.
it's-
Thank you,
yeah.
Mr. Mayor.
You're welcome.
Thank you, Representative Senator Kissel.
Thank you, Mr. Chairman. Hey, thank you for coming to testify. As a kid that grew up in Windsor, and I represent a part of Windsor, I'm just wondering, what part of Windsor do you live in?
So I work right on Bloomfield Avenue.
Wow, I used to live on Lenox Avenue.
Oh, nice. That's awesome. It's a
So
great
is that
town.
pretty close to where you are?
Yes, pretty close.
All right, cool. And I agree with your position on this issue. Just wanted to let you know.
Thank you.
You're welcome. Thank you, Mr.
Thank
Chair.
you. Thank you, Senator Kissel. Are there comments or questions from other members of the committee? I do not see any. That being the case, I'd like to thank you for joining us today to offer your testimony.
Thank you.
I do not have anyone else on my list. I just want to verify that that is correct.
That is correct, Senator.
All right, that being the case, that would bring us to the close of the hearing.
Oh God, you're sending me back to transportation?
I have other committees to go to too as well. That would conclude this hearing. I ask if Rep. Staffstrom has anything, or one of the ranking members, and I would also note that we have a meeting on Friday at 10 a.m. Any commentary from the chair or ranking members? Seeing none, thank you all.
Friday.
I do. My question is, on Friday, what are we tackling? Because we had 13 and a half hours on last Friday. And should I expect the same kind of thing this Friday?
I could never call that, Senator Kissel. So that's beyond
Yeah,
my
but
ability
what
to
are we?
project.
What bill or bills are we tackling?
I believe it's the ERPO. Is that the bill we're doing? Yeah, I believe it's the ERPO bill.
That should not be 3.5 hours.
I have no control over that, Senator Kissel.
We never know. We never know.
There's only two bills
roll
on
of
the
the
agenda,
dice.
Senator. Hopefully it'll go quick.
Right. We hope so. But thank you all for joining us and participating in the public hearing. At this point, I would like to call the public hearing to a close. And I thought I saw a hand again. And thank you all for joining. Have a great day.